a bond. And sometimes, because sometimes it's easier actually to deposit the monies in the registry of the court than it is to get the bond, because you've got to get the principal signing, and then you have to have two separate parties, and they have to in the affidavit indicate that they have non-exempt property in the county of more than the value of that property. And I can't imagine how excited you guys would want to sign an affidavit that you've got funds in, and you may not even have any assets in Collin County, by way of example. So you'd have to find two people in Collin County for purposes of a bond. So whenever you guys are getting sued in small claims court with a jurisdictional limits of $10,000, you get defaulted for $10,000. It's a $20,000 bond. That's hell. Heads start to roll when those things happen. If you're handling something, or you go in, you lose it, it's a lot easier to blame the lawyer. If we lose it, I mean, if we lose it, it probably more than likely we couldn't have won it. It's normally, we're typically prepared, and it may be an issue with the judge or whatever, but you never know. And so, your moral of the story there is be very, very careful when you're getting sued, or your client's getting sued, or you get served with a lawsuit. Your company should have a protocol as to how you're going to handle suits, whether they're suits by vendors, which they're not supposed to be able to serve you or serve a manager or a member of management. And a lot of lawyers don't understand this process. It's not proper service on you, but they'll go ahead and get a default judgment. So you have to be careful. They have to actually serve a registered agent, assuming there is one, or get the owner served. Yes, sir.
I've seen in courts a few times where lawyers come in on foreclosures and stuff, and they charge their fees back to the tenant. The attorney's fees are charged back. With his question is, what we can tell our owners on charging. Can any of these fees be charged? Can we let them know these can be charged back to the tenant?
Well, we normally, when we're representing a party, we normally are asking for attorney's fees. Mm-hmm. And we typically, on average, it depends where, about $1,050 we ballpark it and ask for it. Normally, the client's main concern is getting possession. The only reason why we load up any of the attorney's fees in general, and if we go to the county court, we're also asking for appellate fees, is so that in the event they try to appeal, see, the tenants get confused. They think that appealing from the county court is the same as appealing from the JP court to the county court. An appeal from the JP court to the county court is a trial de novo appeal. It is as if nothing was ever done at the JP court level. And as a matter of fact, the law abrogates the judgment, and it's as if no suit was ever filed. So when you're calling us up and saying, hey, they've moved out, we're normally telling you, well, don't dismiss your suit because you're technically without any judgment. And we're normally recommending you go forward, get a judgment with them, and if whether it's possession or not possession, but getting your rents, so that if later they decide that you have wrongfully confiscated something, or you did something wrong, you've got a judgment there that you can use. Because if you have if you can show that the tenant breached, that relieves you from obligations under a contractual basis that you don't have to perform. And then you can also, if you have a judgment against them, you can also garnish them while you're going after them, and you can do bad things. But it's normally good to get and important to actually get a judgment against a party if in fact they're liable, and not summarily dismiss it. Now sometimes the owner says they don't want to pay the expense, and that's fine. And that's probably going to come more into play starting after January of next year, because the law has changed. And in order to appeal the case, under a pauper status, using a pauper's affidavit, the legislature has changed the law to allow the JP to require 1 month's rent in the registry of the court, or issue a temporary or to issue an interim writ of possession. And how that's going to affect things, I don't know, because I know owners the appeal goes on nevertheless. If you dismiss the case after you've gotten the possession, the costs, all of those costs, whatever it is, a few $100s worth of a few $100, $300, $350 to appeal it worth of costs, those are supposed to get taxed back to the plaintiff and have to be paid for by in this case, or your case, the owner of the property. I have actually talked to the parties, both sides, the Apartment Association folks that lobbied for this, and the tenants lawyers that testified in Austin. And believe it or not, the well-known tenants lawyer in Austin could not explain to me, well, what happens here, what happens there, didn't think about it. Like, for example, let's say that you get possession of the property, case goes on somehow, and there's going to be a question as to whether you have a right to non-suit it. I think you do. To dismiss the case and not go forward on it, cost gets taxed to you. But if somehow you go forward and there's a determination that you didn't give the proper notice to vacate, and that possession was actually theirs and you got wrongful possession of it, well, what happens then? You know, do you have to then allow them to move back in after you've moved them out? What happens if you've relet it and there's somebody else there? Nobody can answer those questions. Now, one lawyer I know that's active in legal, used to be with Legal Services in North Texas, and he's an active tenant lawyer, thinks that might increase the number of lawsuits against folks for wrongful evictions and things like that. So once you dismiss the case, an active case is as if there's no ruling. The JP Court judgment is not, while it may be there physically under the law, it has no application. It's as if you never got a judgment. So be aware of that. I think that there is a possibility. I think that once these things start going through, you might see a lot of tenants asking for jury trials to delay things, which means that leases will need to be changed or adding addenda to put mutual waivers of jury trials to avoid that. So I don't know what's going to happen. It hasn't yet happened January 1st, so there's going to be a big change in that regard.